from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state, which all are multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Carrim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Carrim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Carrim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Carrim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Carrim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Carrim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Carrim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Carrim's appearance or non-appearance to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Carrim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Carrim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Mr. Justin, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Shoskowski. Yes, Mr. President.
I'm just raising my concern about the manner, and then that's the direct answer.
Maybe instead of impropriety, I should have said concern, which is a word you've just used now.
Yes. So, Chair, I think we're ad idem then that it's concern, not impropriety, and formally in writing, because these are very serious accusations, and I understand that my learned friend is under his collegial obligation to give me notice that he was going to raise it today at the hearing, but he could have we could have reached some or other arrangement about being informed about this formally and then given an opportunity to respond. But we are where we are now, so that's water under the bridge, I suppose.
Yeah, I was going to say, why is it that the informal advice cannot serve the same purpose as written advice?
Well, I suppose because my learned friend is not the witness. So when my learned friend, and neither am I. So when my learned friend says to me, these are the core of the allegations, it might turn out that some or other detail about that is going to change or not change, and there should never be a dispute between my learned friend and I as to what he said to me or what he didn't say to me. I mean, if my complaint is at this point only boiling down to housekeeping about the form of communicating the information, I accept that might not be an issue which needs to detain the Commission.
The issue, as I understand it, is not so much about the interaction between the two of you. It's about Mr. Carrim addressing what we are told has since been discovered.
Yes.
So the focus is less about the interaction between the two of you.
Exactly.
And the point being, if indeed it is true that Mr. Carrim was at some food outlet out of town, I think reference was made to his vehicle or vehicles. I'm not sure now whether one or two or more. So point is, when you apply for the postponement, why is it, or rather when Mr. Carrim applies for the postponement, why is it that he should not, in the application for a postponement, deal with those? If he says, I was never out of town, I was never at this alleged food outlet, and therefore my medical certificate stands, and it is to this effect, nothing has changed, I do not see what the hurdle is, Mr. Carrim, dealing with the new information on that basis.
Agreed, but I think that's also I'm sorry, Chair.
Yes.
May I respond?
Yes, please.
Thank you, Chair. But that's the point, with all due respect, is that, remember, when we arrived here in front of you today, it was on the basis of what was known before my learned friend disclosed the new information. But now what's happening is new information is being introduced, which may need to be dealt with to justify future postponement, but the basis upon which we're here in front of you today is the different historical facts, not the new facts introduced now.
The constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted. And
Is there a signed affidavit now?
There's indeed a sign. It was commissioned this morning, and we thank the commissions, my learned friend and her team, for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavour made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you. Chairperson,
in short, we set out the history of what's transpired vis-a-vis Mr. Matlala when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both witness C and Lieutenant General Nkomazi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings?
May I please you, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You see, I'm raising the point that that was a minority judgment, to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
The state said, we wish to continue. He asked us and we said, no, we assail from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what's happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains is based on facts and where we can invoke that right correctly, I cannot even go as far as to say we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present, in your, and I mean the Commission, the Royal U, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show.
Please tell me when you are done with responding to my question.
Yeah. So,
before you move on to another point.
I basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then asked you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level,
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of this Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process? So
there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing, and I need to understand in those negotiations who, what, and where. And without that, I cannot,
Are you talking negotiations relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now, please.
It's not history, because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not
But
committed to.
is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir, if-
I'm asking you about the precedence.
Yes, but
Which of the two processes must precede the other? So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end. That's something else altogether.
No, that's not.
It has nothing to do with whether, once the plea deal is dead and buried, must the commission process wait for the criminal process. So the earlier issue, the plea deal, is finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for
purpose
what
of
purpose?
invoking my right to silence on that. I can say I've been
then
told.
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that post the plea deal may also fall under the section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside and let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket. Even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to the next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please, rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I
have not asked you that. You are trying to answer a question which I've not asked you. I've not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is on those issues on which there is no question whatsoever. Those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket on those issues. And again, I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process, what would the basis of not doing so be?
The only basis to the state
throughout is I need to see what was discussed with IDEC, which I say, and I say it firmly, is completely irrelevant for purposes of your postponement and for our purposes. You keep on saying that, but in fact what you should be saying to us is Mr. Matlala refuses to submit a statement to the commission because of ABCD. Then we deal with it on that basis. Thank you.
Commissioner, there's a few issues. The one thing that I've noted in the 10-6 that you, I assume, take quite seriously, there's a specific question that says, has any person tried to influence you, intimidate you, etc.? Now, you cannot say to me that that is not relevant to the Commission's work.
The answer can only be yes or no. And the rest would be the detail. If we are interested in a yes, if he says, yes, someone has tried to intimidate me, the commission may well follow up when he presents evidence and say, well, give us the detail of that intimidation. But the answer is yes or no. There's nothing, there's no privilege about it. There's absolutely, and it's a matter that is within his personal knowledge. It doesn't depend on you seeing the documents from IDEC. It's an answer that Mr. Matlala is in a position to give to you. So it's a bad example that you're choosing.
No, I respectfully disagree with you because if there are, if for instance there's intimidation or for instance if there's undue influence, with the greatest respect, I've come across and I've got no problem that you yourself have come across people that do not understand that what they are subjected to is undue influence to get to a point. So I stand by my answer previously. The other issue that I want to raise with you is, as a litigator, we've got ethical obligations when we deal with clients to ensure, and you're right, I advise my client, that is my duty, but I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client, because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
Can I
Is it something that can be done for this commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
Chairperson, the situation is...
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
No, it is different, because when people enter into plea deals, there's certain consensus reached, and it goes... it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that, to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows, and that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoked my right here and there and whatever, when I know in law the situation is that is a life process and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the commission wants to hear from Mr. Matlala, get his and underline his facts. You emphasize facts coming from General Mkonazi, and I add him and others. You emphasize those facts. What the commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkonazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept. And we can show you in due course why you shouldn't.
We've not accepted anything.
Example.
We've not accepted anything at
No,
this
but I'm saying to you, it's just one example.
Yeah.
If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want...
Commissioner Kumalo asks a question. He says his point is now covered.
Okay.
You said earlier you had a discussion about timelines or the timing. I just want to find out at this stage, before you continue with the rest of your submissions, to find out by when the statement that you say can be filed. By when will that be filed?
Chairperson, I've not
I know perhaps it's something you may want to engage Ms. Silo about, but I would just like to hear from you.
May I take an instruction just?
Yes, yes.
In 2 weeks, of course, please take into account we're starting a trial on Monday. And that is, of course, also premised on the fact that we get the recordings that's been referred to and relied on by certain witnesses in the commission. And I've discussed another issue with my learned friend, but I'm not going to deal with this on the record. Me and her have managed so far to, between us, sort these issues out. So if it's convenient and if so permitted by the commission, my attorney says that we can probably do that in the next 2 weeks. Because, of course, maybe just for the record, we can also obtain some of the information through the erstwhile attorney. So.
on this and possibly any other issues that may require discussion between you and your colleague, Ms. Van den Heever, we'll give you time, so we will adjourn before any ruling is made. But I don't think you were done with your submissions unless you tell us that you are. If not, you may continue.
I think my submissions are quite clear pertaining to the upcoming trial. I think we have the right to be presumed innocent. This commission is watched by many, many people, and I'm just afraid, as it goes, the questioning of him, and I'm not necessarily saying by yourselves, but I know my learned friend might give the perception that he's guilty, and he will go into his trial with baggage, and I'm trying to prevent that. I've set out for you, I think, quite clear the issues that we are dealing with, and then, of course, I'm asking you to pay serious consideration to what is contained in the opinion that we've urgently obtained for you, because I find it very persuading. I hope you do too, and we are endeavouring to deal with that issues the best we can. Thank you very much. Sorry, Chairperson, my attorney has just asked me to emphasize the point that part of the delay had to do with the recordings that was not given to us.
Sorry. So I'll give you an opportunity. You just... Ms. Van den Heever, we heard what you say, and what you said you wanted to emphasize, unless you want to add to that.
Your position is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDEC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala, and he will never testify. Is that what you're saying?
No, that's not what I said.
Then what is the relevance of the IDEC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so. The second issue is, and I want to almost...
what is the opportunity? I think...
I want to postpone it.
I want to make sure that we understand what it is you are seeking from us commissioners. When you say, you are not saying that until you've received the IDEC material, Mr. Matlala can never submit a statement and he can never testify. You're saying that's not your position.
My position is not, it doesn't only relate to IDEC. Can you just go one step?
Let's take it one step at a time.
Sorry, thank you.
It goes further. The Commission is in possession of recordings that was only disclosed to us. Hold on. I want us to do one step at a time so that we tick off what is the issue. If we've resolved an issue, we
we both agree this is off the table now. Now we are going to a different topic. I know that in your affidavit you do speak to recordings and transcripts. We will still get there. You haven't engaged with that. I still just want to be clear, because my understanding from the time when you were engaging with the chairperson, and hence my questions that I've asked of you, my understanding of your position was, and still continues to be, that until you have received from IDEC, whenever that will be, if they will ever give you that material, until that point that you've received that material, Mr. Matlala can never depose to a statement, because you would not let your client depose to an affidavit where in future he gets met with previous inconsistent statements and all of that. So I ask the question so that there's absolute clarity about what it is that we are dealing with. Is your position, let me repeat, is the position that you are adopting that until you have received the IDEC material that led to the now collapsed plea deal, Mr. Matlala will not be in a position to file a statement to the commission, and Mr. Matlala is not in a position to testify before the commission.
Chairperson, of course, that is my position at this point in time, because I'm ethically bound to act in that manner. I say to you, I cannot think of any other council that would act differently than I do. So, but this is not an impediment, because I truly believe we can get the information relatively quickly. So I'm saying to you, please just take into account this plea deal collapsed on Monday. It's Wednesday. So we've got this very short period, but that's not the only thing that I say.
No, don't go to the other things.
A witness whose testimony was deferred to later in the morning, and I'm quite mindful of that witness. So that constrains me significantly as to how I respond. So I will try to be as brief as possible, and so doing, perhaps to assist the commissioners. I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. We have spent over an hour engaging, or my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts, as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument, if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
Now-
sorry,
Yes.
Mr. Lo. Can you please make me understand something Ms. Van der Heever said on the 7th?
Yes, Chair.
Ms. Van der Heever indicated that she was agreeing to the filing
Yes.
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding.
Of course, maybe I should have asked, I should have put that question to Ms. Van der Heever.
It's a subject, of course, to Ms. Van der Heever confirming.
Yeah.
But I'd understood that the proviso was file on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file, an undertaking
yes.
not to file.
And in fact,
It's even wrong for me to refer to the latter as an undertaking, yeah.
And in fact, that proviso was discussed amongst ourselves. Because of the tight timeline, I think Commissioner Baloyi indicates there's shaking her head as if I misunderstood her.
I think the ultimate position was they will file a statement.
If it is wholly unconditional by a specified date, then I'm happy. Because my concern was that if they do not get the required information from IDEC, or IDEC just outright refuses, then they would be entitled in law to approach a court to compel IDEC to provide such information if they have a basis in law to do so. And if that court case is unfavorable to them, there are appeal proceedings. So the question would be, do we await that information and the challenge to right to that information to run its course until the Constitutional Court before we get a statement? But I will accept what Commissioner Baloyi says the filing in 2 weeks is unconditional. If that is the case, then we just need to set a date. And if the statement is not filed, we shall be back before you, Chair. And I suggest that the consequences will follow. What then must happen now is to lock in a date, as we did of the 15th that has now collapsed, as to when Mr. Matlala will appear. And I say so because we as the evidence leaders have to go rejig our program and accommodate the new dates, while at the same time making sure that there is sufficient time for everybody to prepare for Mr. Matlala's appearance before you.
Would the preference be for the postponement to be to a specific date or a date to be determined?
No, Chair, I would prefer a specific date at this point.
Specific, all
Yes.
right. All right, please continue then.
I think
Maybe something from the Commission side that we should, without making a ruling, that from DCS side that they should do whatever they can to assist us. I think that would go a long way. That would give us something in the hand to now go and do from our side what we need to do. Thank you. I've got nothing else.
Nothing else.
I agree with my learned friend then that we discuss inter partes the date.
Yes, all right.
Ms. Van der Heever, without getting into it, I just want to know its status. The opinion letter, I'm not getting into it. Was it filed just for the purpose of today's postponement? It was to deal with just today.
Oops. Doesn't work. Oh, there it goes. It was done for today because of, as I said, that's all I wanted to say.
Yeah, it doesn't go beyond.
There are other reports and things that's been drafted. We have been communicating with the head of prison with regard to the issues, but I don't want to go into that further at this point.
No. It was just for today's postponement.
For
That's all I
today,
wanted
and the
to
relevant
understand.
part of it, you'll find about the issue of, I mean, you've read it.
Leave it there. That's fine. Thank you, answered.
Chair, if I may, for the record, to correct for the record and posterity. Ms. van der Heever speaks of being provided with random extractions from recordings. That's wholly incorrect. The recordings that were provided were recordings that were played in this commission during the testimonies of witnesses. As we do when we provide our Rule 3s, we provide the evidence that implicates the particular witness. Perhaps the commissioners to consider a possible date. My learned friend will confirm. I understood that the upcoming trial that starts on the 20th.
Just a minute.
Yes.
I think on your last point about the date, I think it would be better for you and Ms. van den Heever to engage, and then, which of course would necessitate a stand down. And when we come back, hopefully we'll get an agreed date.
Oh, no, I'm happy with that approach,
Yes.
as long as I come out of this hearing with a ruling on a date. However that point is reached is irrelevant. I'll accept that, Chair.
Any further submissions?
No, Chair, I think that will suffice. I'm looking at the time. As the commissioners are aware, there's another administrative issue to deal with before my witness returns to complete his testimony.
Any reply, Ms. van den
I'm
Heever?
going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way we level the playing field. So it's also that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that a judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him, so...
Then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
Thank you. One other thing, at least based on the agreement that has just been conveyed to me, I assume that you will not be insisting on reasons for the fact that we are saying the hearing will be continuing.
I do not need any reasons. May it please you. Thank you.
Thank you. I thought I should just take care of that because there was the muted reference to the possibility of a High Court application. So one might say no reasons were ever given for an application that we made.
Like they say, I don't roll that way, Chairperson.
Thank you. I make the following ruling. Mr. Matlala must file his statement not later than 29 July 2026. And that's 1. 2, the hearing of his testimony is postponed to 1 September 2026 to continue until the hearing has been finalized.
Thank you very much, Chairperson.
Thank you.
Thank you, Chair.
Thank you. Mr. Matlala, Ms. Vandenhoeven, you are excused. And because we are continuing with you, Ms. Sillo, you are not excused.
Chair,
Is it?
it's not with
or
me
for
for the
later?
next admin issue, yes. So
Still,
thereafter I come
still
back.
you are with us later in the day, of course.
Yes,
But
thank
thank you.